I want to give an overview of a hot topic right now relating to operating under the influence cases, specifically breathalyzers in Massachusetts. In 2019, after significant litigation, a final order of the court came down, which in summary stated that all breath tests in Massachusetts were presumptively unreliable from June 2011 through April 2019. I'm not going to get into how and why the court made that particular finding, because this vlog is just about what does that mean now. So while I've used that finding from 2019 to my client's benefit many times since then, now in 2021 the calls are just pouring in because the district attorneys recently sent out letters to individuals who may have had OUI cases affected by those faulty breathalyzers. Now I've seen the letters that they're sending out and they're kind of cryptic. They basically say that if you either pled guilty, admitted to sufficient facts known as a continuance without a finding, or if you were convicted after trial for an OUI that involved a breathalyzer which has since been deemed unreliable, you may have legal recourse. It's a template letter that the district attorneys were required to send out to tens of thousands of people, and most people have no idea what to do with this information. So now I'm here to give a quick overview. I'm sorry to say that I've disappointed a lot of people who've called my office when I tell them, no, this doesn't mean that you're entitled to having your record expunged now. What it does mean is that after a review of your case with your lawyer, you may have grounds to file a motion for a new trial. The grounds for such a motion will vary depending on the specific circumstances of your case. Judges will essentially be looking at whether there likely would have been a different result in your case but for the breath test that has since been deemed unreliable. If you took your case to trial and the breath test was used as evidence at that trial, and the rest of the evidence against you wasn't overwhelming, then you'll probably have a pretty good chance to have that conviction overturned. If you pled guilty to an OUI or admitted to sufficient facts for a finding of guilty and received a quaff because of a high breath test result that you and your attorney thought made your case unwinnable, and if the rest of the evidence against you wasn't too strong, then you also probably have a pretty good chance to have that plea overturned if you can convince the judge that but for that unreliable breath test, you never would have taken your case to trial, or you would have taken your case to trial rather than taking that plea. Now, it's important to realize that even if you win your motion for a new trial, that's exactly what it means. Your plea gets overturned, and now you get a new trial where the breath test evidence against you can't be used. For most people who've moved on with their lives and who no longer have their licenses suspended, it's probably not worth doing anything at this point, because you'll have significant legal fees to do so. The stress of, once again, will come in of you being a defendant in a criminal case, and then if you lose, you risk another license suspension. However, if you now have multiple OUIs, or if you're facing a subsequent OUI charge, and your prior faulty breath test OUI case is now being used to enhance the penalties against you, then it's definitely worth talking to a lawyer about a motion for a new trial on that case. Also, if you now have immigration or other personal consequences, such as employment, as a result of a faulty breath test case, then you again should speak with a criminal defense attorney about your options. We can help evaluate your personal circumstances as well as the remaining non-breath test evidence against you in your particular case to help you make an informed decision. So feel free to contact us, give us a call, check out our website for your initial free consultation related to your bad breath test OUI case from 2011 through 2019.